Good afternoon and welcome to lunch. I'm Judge Margaret McKeown from the Ninth Circuit, and I have the privilege to moderate a conversation here today. Again, special thanks to Bob Cummins and the Cummins Family Justice Foundation. Today, we're going to have the wonderful privilege to have a conversation with Justice Stephen Breyer, former justice on the U.S. Supreme Court, prolific author, and of course, now professor. And also with Diane Wood, former chief of the Seventh Circuit and now director of the American Law Institute, also a professor. I've known them all for so long that I will probably just call them Steve and Diane with their permission. So I don't want you to think I'm disrespecting them in any way. But we've titled the program Judicial Independence in a Challenging Environment, say no more. But one of the things when we say judicial independence, and then that is tested with the public tends to think, yeah, judicial independence means judges run wild and they can do whatever they want to do. So what is your perception of that and how do we change that? Let's start with you, Steve.
Independence, you're not going to change. People normally read the paper, and if they like the result, they say it's great. And if they don't like the result, they say it isn't. You think you can change that? Let's go back to Adam and Eve. I mean, really. The independence, the best thing I've heard about that was Tony Kennedy speaking to some Russian judges who some years ago, soon after the Iron Curtain came out, that was lifted, they were at the court. He was talking about independence. He said, maybe you'll be independent. I'm not sure they see that. Maybe you won't. But I'll tell you something about independence. No one will know if you are independent, except you. Were you honest about that record? The one who favors the lawyer will say it was great, of course. The other lawyer, he won't say anything because he's just thinking about it being a great lawyer, not, and well, anyway, you got the point. You know, though. You know. Do I want the New York Times to say something nice about me? Is that why I put that in? No one will know. I'd say the time they say something probably nice is when they say, I wasn't brave. That's right. You know, though. You know. And the most another judge can do in respect to independence of you or me or somebody else is to know what it feels like. As to know what it feels like when you're pushed one way or another. So, of course, I'll say independence is necessary. It's great. It's important. It's internal. And those sort of cliches are the most I can say about. And they don't mean it's unimportant. It is. I said that. Harry Reid, after Bush v. Gore, came to the court, and he said the most remarkable thing about that case, he's never remarked, it is that despite the fact that it was wrong, that was his opinion, and that was my opinion, is important part of it, wrong, harmful, half the country against it, maybe a few more than half, but people followed it. I'm telling this to the woman who is the president of the court of the Supreme Court, and she wants it. She said, why do people do what you say? A long time. Habit. For the years. All that said. So I just repeated. I repeated it to the students at Stanford, who might as well name names. I said, just what he said. And I said, now I know the truth is that 1/3 of you in this class, maybe half, think too bad it was so no stones thrown, no paving stone. She likes France. She teaches in France, in France. It's pretty impressive. And she said, yeah, you were thinking too bad there weren't a few paving stones. So I say, before you come to that conclusion, turn on your television set or what they have now. Turn it on and say, how do countries function? Do you like the way they function when they don't have a rule of law, when there isn't judicial independence? Is that really what you want? Ask yourself that. Okay, so I've tried to explain, I think it's important, which is hardly surprising. They think a judge thinks judicial independence is important. That's why people don't do what we say outside of the case. And Lee Campbell told me that you're a judge now, 42 years ago. A judge is a person with power in a small area. And that's true of the Supreme Court too, much smaller than this. But as soon as that judge, he or she, begins to give your opinion on something that's not in that case, the lawyers will say, oh, very interesting, Judge. What an interesting thought. And then they'll go outside and they'll say to each other, there he goes again. See, that's my basic point. It's not the lawyers. It is the lawyers. It is not the judges. And it's not the judges. It is the lawyers that have to help in this situation. Okay, we'll get into the situation later.
Go ahead.
Hard to follow, but what I will say is that I think we have a need for the public to understand what Justice Breyer was just talking about. And we have a need for the public who pick up that, whatever it is, it's probably their phone, and read a news feed on it, to say, what made the judges do this thing? Did they do it just because they were in the mood that morning? In that sense of independence, like a 2-year-old saying to you, I'm going to stomp my feet all day? Or did they do it because of something else, some elusive concept of following the law, whatever that may be? And the public, we judges need to convince the public somehow through our opinions, maybe even through public appearances such as this, maybe through books that we write, that there are constraints. And when we talk about judicial independence, that feeling inside yourself, that you've done the best you can to call the case the way you see it, whether it's going to be deeply unpopular with the people that you live with, whether you're going to, I'm thinking, for example, of the feelings that ran both ways on the assault weapons ban that Illinois had. Some people felt very firmly that this was a profound intrusion on personal rights. Some people felt just as firmly that this was the only way we could begin to curb hideous acts of violence in society. So, how do you make that choice? People need to believe that there's something principled behind it. And the judges who are making that choice need to feel like they're not going to lose their job like 100 of the immigration judges just did, because they weren't coming out with decisions that pleased the executive powers that be. But in the regular federal courts, losing your job isn't a consequence of coming up with maybe a stupid, maybe an unpopular, maybe flawed opinion in whatever ways it may be flawed. It's instead your prerogative to decide that case. If you're on a court of appeals with a couple of other judges, if you're on the Supreme Court with 8 other people, whoever is doing it, you decide it according to your understanding of the way the legal system is supposed to work. The public doesn't like the courts that much anymore. The opinion rankings of the courts, and the Supreme Court in particular, have been sinking. They're not in negative territory, thank heaven, but the courts are being watched, and the public, I don't think it's just that the bottom line isn't right. I think they're concerned that it's really just one more committee of the Senate. There's a certain number of Republicans and a certain number of Democrats, and then you can just predict how it's going to come out. I didn't think that was the case when I was on the 7th Circuit, and I hope that it is not the case now.
I want to go back to something you said, Steve, about Bush v. Gore. That was a time when I was actually going to Venezuela to speak about rule of law. And our president had called the head of the country the crackpot from Caracas. So it's not really a prime time environment for me to be visiting on behalf of the rule of law. And when I was on a radio call-in show, somebody said, how could you possibly talk about judicial independence and democracy after Bush v. Gore? And I was not prepared for that question. But what did occur to me in what I said was whether the public agreed or disagreed with that decision. The next day, we woke up, we didn't riot, everybody went to their job, they went to school, and they carried on their lives. And I think that really was a representation of following the court of what we were supposed to do, but also what we meant by democracy. So my question is, do you think you'd have the same environment today if there were Bush v. Gore number two with a different situation?
For you.
I don't know.
We don't know.
And of course I don't know. I think that we have a problem today, and we have an audience today that is not the same as problems that are somewhat similar in the past. Joanna, my wife, pointed this out. We flew out here on United. We've all flown on airplanes. Okay? Now, the first thing you see on that screen is something sort of funny. They now do the safety thing with comical balls dancing or the history of England or somebody with a bow and arrow. Why? Why have they changed that? The audience. Because they're young and because there's no television set. There is a television set. There is no, what was the thing? It used to be some books. Books. That's it. I knew if I went back into my history, 80 some odd years, I think of that word, books. There are. Why? Because they know who's using the room. And they know 2 screens is better than books. Now, I'm sorry, I have no cure for that. That is the world. And those are the people that you have to convince that it is worth having an independent judiciary. Okay? Who can do that? The judges? No. I mean, I have heard some good ideas. I think maybe we should have in the Supreme Court. Maybe we should have a group, a person whose job it is, and maybe some lawyers on a committee will explain what the opinion is. Why not? Because we're afraid, and I'd be a little afraid too if people are against it, that all they do is have one more ground for everybody disputing what the person's saying. But you can do it in the circuit without having so much. Maybe we shouldn't be afraid so much.
They do it in Canada.
Yeah, I know they do it in Canada. That's true. But they lock up the reporters in Canada for a day so that they see that they actually read the opinion before they talk about it. They do. I expect they do.
I
Okay.
think we need a certification.
They're sworn to secrecy.
Yeah.
Yeah. So what do I think the judges can do? Not very much. They can behave as well as they can. And sure, talk to students. Sure, go to school. Maybe if you're very brave, you'd even talk to an editorial board. But you're not going to get too far, in my pessimistic view, on that. But that may be worth doing. And how do you write your opinions? I learned this. I hope that you remember John Wisdom. John Wisdom was part of the great Fifth Circuit. John Wisdom was one of those judges who, after Brown, said, we're going to see that this is enforced. Easy to say, not so hard to easy to do at that time. And when he retired, he came up to the First Circuit when I was first sitting 43 years ago. And I talked to him a lot. And he was great. And he said, here's how you write. We were talking about writing dissents. And he said, here's what you do. When your colleagues write something that you think is absolutely wrong, and you've got to dissent, you sit down at the typewriter. We only had typewriters. They had invented pencils and pens. You sit down at the typewriter and you write something that really says how awful you think it is, and the person who wrote it is beyond belief, and how can anybody do this? It's just not awful, and then you read it, and then throw it in the wastebasket. He said, and then you write a judicial opinion. And that's what I've tried to do, which is not everybody's cup of tea. And it is not everybody's way that they have to react. I can't blame somebody who might feel differently about it. But what I would do is I would write so that it says something that may be terrible about this person, may be terrible about this decision, but it's not me who's going to say it's terrible. I'm just going to say it's wrong. And I'm going to say it's wrong and explain why. But what I secretly want to happen, which I will tell you, is that I've written it in a style, if it's very important. So the 7-year-old is going to think this is terrible. And it's that 7-year-old I want to say this is idiotic and how could the person ever do that? Not me. Nobody's going to believe me. But you see the difference? Now, that's been my own approach. And I'll tell you that sometimes it works and sometimes it does not. And so people have to choose their own approach and have to decide. But Lee Campbell, yes.
Before I ask Diane, I want to follow up on that. Have you found in your time that writing the dissent, well, not only sharpens the majority, but sometimes you can shift and the majority can.
Sometimes. I'd say the sometimes is this, the people heard it in conference in the Supreme Court. Okay, here's what I tell lawsuits. It's true. I was 28 years on the Supreme Court. I never once heard one judge in that conference room shout, scream, be mean to somebody else, or say something critical that is mean and not appropriate. It is professional. We would go around the table. And I was last for 11 years. I almost got the
To
record.
be precise.
Yeah, I was last. I was the most junior for 11 years. I missed it by 11 days. When Alito was appointed, I thought of writing to him and saying, please, can't you wait 12 days? Wait 12 days to get sworn in. I'll go down in history as the answer to a trivia question. Fabulous. But nonetheless, I did. Okay, so it's professional. Now, the other thing I want them to take into, is what's the advantage of being last? Is an advantage a disadvantage? The disadvantage is people they get embedded in their approach. Too late. The advantage here, what they say. Nobody speaks twice till everybody speaks once. Sandra O'Connor told me that was a great rule, and I completely agree. Everybody has a chance to be heard. But then, what am I listening for? I'll tell you this, and any lawyer or any judge knows this on an appeals court. When you have, look, you say something when it's your turn, and the underlying, what you think is secret, it isn't secret. The underlying theme is, I have a much smarter argument than you. I'll tell you what that leads to. The person you're talking to thinks, no, I have a better argument than you. That gets you nowhere. But if you sit there and you listen and you ask, where are they coming from? Where is it? What's their real point? Why are they thinking this? What is important to them? What can I do that will help produce something at least a little bit? I love first speakers. And they know will produce sometimes a little bit closer to what I want. Maybe you reach a compromise. And maybe on some occasions actually change people's minds. Yeah. What I can do is listen. What I can do is listen to what they say, see where they're coming from, and see how much room I have given basic beliefs to move a little bit this way or that way, and expect them to do the same and get a real conversation. Go to the Second Circuit. I'm afraid you don't have this in the First Circuit. That's just, I know. The First Circuit, look, I was in the First Circuit for 12 years, 14 years. So I think every circuit is the First Circuit. But no. Go to the second, because limited hand filled that bench. And the bench is at the same, so the judges are the same eye level as the judge and lawyer. So what you want, and only occasionally do you get it, only occasionally, you get that lawyer to think about his role as a bankruptcy judge where he knows all of those things. And get him to think about that. Get him to forget for 2.5 seconds that he's representing someone. Oh, forget that. That's impossible. But nonetheless, you sometimes get kind of conversation. What will this do to bankruptcy courts? What do you really think? And you learn something. Say, not just an argument. And learn in hand, well, that's the goal. That's why we're building the bench this way. And I can't say you always read, but you see, I'm saying, what can the judges do? They can do their job as judges and then remember it's the public. Okay, you've got it.
Well, I'm going to ask Diane, who is on a slightly different kind of court, and now she's able to reflect back as to what it meant to be a colleague on a different kind of court, sometimes in a bank court, but also a very deft writer of opinions. So what do you think now, looking back on the role of the opinions and also the role of that interplay, that personal interplay among your colleagues?
Well, it's incredibly important. I mean, I think you have to treat all of your colleagues as real colleagues, not, enemies to be faced or allies or anything like that. And I totally agree that you need to figure out what it is that bothers them, maybe generically about a case. Maybe somebody is a real zealot for, Article 3 limitations like standing or mootness or whatever. And so with that colleague, maybe you don't want to waste a lot of time talking about the merits of an appeal. You want to set their mind at ease, whichever way you think it needs to go on that prior point. You need to make them not just the illusion of, but the reality of listening and adapting to what that person says. Interestingly, on the Seventh Circuit, we do it the opposite way in terms of when you speak. Mm-hmm. So the Seventh Circuit is a court of 11 active judges. And so the most junior person speaks first, whether it's a panel of 3 or whether it's the full en banc court. And I remember when I was a brand new judge there thinking, great, out here on the end of a limb. Oh my God. Then I came to love it. I came to think that it was just great to be able to introduce the terms of the debate the way I thought they should be looked at, try to clarify the questions, because there were many times that people kind of accepted the structuring of the case that I had suggested, went along, modified whatever, responded to it. But it was a great position to be in, I thought. And so if it was the en-banc court, junior to most senior, but we had another rule designed, I think, to help that listening and thinking process. And you might say that it's, I don't know, not 100% successful, but what we would do with an en-banc is the most junior person would start first, but you didn't say how you were going to vote in the case. You just had to discuss the case and leave off that final sentence, and therefore I vote to reverse, or whatever you think you're going to do. And the idea was to keep people from backing themselves into a corner too soon. So you would get the full views of all 11 people on the court, and then we would go around the room again. At that point, people could vote, but oftentimes before that second round, you would have Judge A saying to Judge B, tell me a little bit more about why you're concerned about this. And so it was really a very productive crisscross of conversation about the issues that were turning out in the general mind of the court. And only when that phase settled down would, like when I was chief judge, you kind of waited for that moment. You could feel it. And then you would say, okay, I think we're ready to vote. If somebody else said, oh no, I still have something to say, then that was fine. But usually you knew. And then you would go around again, and the votes would be more nuanced. Sometimes, obviously, in cases, there are a couple of different theories that you might use. You might decide narrowly. You might come up with some sweeping, broad rule of law that's important for a field. But that listening process often shaped what the final opinion was going to look like. And I say shaped because it didn't. Lawyers always say, well, how many times, did you walk in thinking you wanted to reverse and you left thinking you wanted to affirm? Not that many times, but I have said to people, by the time I've read all the briefs in a case, I've read what the district court has done, I've looked at the authorities that seem to me to be the most important ones. I've given the case a lot of time. I don't walk in as a blank slate. I mean, that's not realistic. But I might find one theory more attractive than another. Maybe one theory is going to command a majority of the court or all 3 members of the panel. So instead of having a split result, you have something that's more usable, just a better result. So that's how we did it. Now I want to actually respond to one other thing though that Steve said. I think that judges do in fact behave, at least my experience was the same as what you're saying. No one was raising their voice, nobody was calling anyone names, no one was saying, how can you take such a stupid position? I mean, nothing like that. That never happened, no matter who the judge was, no matter what president appointed them, nothing like that. When people sit down to write, some of that restraint goes away in my experience. Right? I'm hearing a sound of, yes, maybe we've all seen this. Think of how many ill-considered emails have been sent around where you just shoot off an email right off the top of your head. And you actually wish that you didn't phrase it quite that way. Well, that does happen. And it happens when, say, the assigned judge circulates an opinion to the other judges, whether it's the full and back court or whether it's the other two on the panel, and then you wait to see what's going to happen. And maybe you probably know in advance that one of them is inclined to write separately, either dissenting or concurring. Well, if you get back something that's just filled with purple prose, I won't tell you who this was, but early on when I was on the Seventh Circuit, you can probably find it. There was an en-banc case that we actually made quite a mess of it. It was a very, very long opinion with 7 different opinions. It eventually went up to the Supreme Court. They resolved it in a way that reminded me of the History of the World Part 1, where Mel Brooks is saying it's good to be the king. Because the Supreme Court made up a defense that hadn't been there in the statute. And I thought, well, I didn't realize I was free to do that. But but anyway, it sort of resolved one of the big issues in the case. But one of the people who was disagreeing with the position that I had taken, and I had actually been the panel opinion writer, decided to boldface my name every time he referred to it in the opinion. He dropped a footnote at the beginning of his opinion in which he said, when I refer to Judge Wood, I'm referring to Judge Diane Wood. This court also has a very distinguished judge named Harlington Wood on it. I was like, okay, I get the message, to the point where I came to an event over here at the Chicago bar. I was just some lunch. I don't remember the topic of the lunch, but it was over here. And a lawyer came up to me and just stood there in front of me for a minute. And I said, can I help you? What's going on? And he said, I'm just checking to see if you're bleeding. And I said, no. I said, it takes more than that. But anyway, it was a very pointed and unfortunate way of handling things. And I think sometimes at the Supreme Court level, my personal opinion is certain justices got a little carried away. Instead of keeping to the legal arguments, the attacks got a little personal against other justices. And I think that diminishes the courts in the eyes of the public at large. It doesn't really help the analysis of the case. I like what Steve was saying. Give your reasons. You think something should happen, you ought to have a reason for that. And it ought to be a reason that's comprehensible to other people. So I think we can all, the people who are still judges, when I was a judge, really tried hard to make sure, I thought of it in the Godfather sense, it was business, not personal. And so I was trying to make sure. And then at that point, let the chips fall where they may. People may agree, they may not agree. That's fine. That's the nature of the business. But you really have to resist that urge to rant.
It's what we call the mean, actually. I might add that the Ninth Circuit has something in process very similar to the Seventh, and that the junior judge goes first. And in an en-banc court, which by statute, we have a partial en-banc of 11, same as the Seventh Circuit. When you are the junior judge, it is downright terrifying to have to go first, but it's also very empowering because you realize you can shape the conversations. So it's always interesting to see how other courts do it. The Supreme Court, you get one word is the last word, is what you get. But one thing I want to ask about, because it underlies all this discussion on judicial independence, and that's politics. right now, polls show, of course, that a lot of citizens feel that the courts are political. And I might say that those of us in what are called the lower federal courts, that what happens in the Supreme Court reflects on us in terms of citizen perception. But on this topic of politics, and I know Steve has a lot of views on that, I'm going to ask Diane first. What do you do when people say, well, the courts are just political, we know how they're going to vote, it's predictable, and where's the independence in politics?
Well, I'll be brief, but I mean, people do say that, and there's no doubt that there are some opinions from the Supreme Court in today's world, let's say, that are 6-3, and you know who the 6 are, and you know who the 3 are. Does that make them, I'm not quite sure what that means to say, does that make them political? They all come with ideological views about the nature of courts. They come with things that are like meta politics somehow. It's not just, we're going to build a new highway across your backyard. It's a different kind of political that we're talking about. People never look at the other side of it. I worry about the problem of the denominator. I mean, there certainly are cases, again, like this, a 6-3 or something of that sort. But there are many cases where votes get shuffled up in ways. Certainly this happened in the Seventh Circuit. I mean, I remember well colleagues who were appointed by this president or that president. And I thought, you can't predict how they're going to vote just because you happen to know the president. That, I mean, easy enough to find out, right? That you know the president who appointed them. So it's the standout cases, but then they add the word always to it. And that's a mistake, I think.
I think you have a few views on this. You've written some books on judges not being political, et cetera.
Politics is the wrong word. Correct word, I think, is what Diane said. Look, as soon as there's a vacancy on the Supreme Court, every political group in the country is up in arms and trying to get their way and so forth. So they look for a judge whose views on the law will, they think, lead to views that they like politically, and they lobby for them. And they're sometimes right on that, not all of them, but some. Okay, but the judge thinks that he's deciding it according to what the law is. I did write a book about this. But I was looking for it, the veteran wasn't there. Okay, but the judge thinks he's doing it according to law. That's why the title of my book was Why I'm Against Textualism and Originalism. Okay, there are people who could hold the opposite view. I don't see how, but they do. And there we are. That's not political. And also, again, this is the Supreme Court. You get cases, you see, you wouldn't get the cases there. They wouldn't be there unless lower court judges have come to different conclusions. That's almost always true. And so, of course, they're difficult. I mean, the lower judges are fine, and they're on the same track for just 99% of the time. Okay? So you're not going to get that. You're getting exactly what you say. I counted them one year. They're usually about 40% are unanimous, and about maybe 5%, 10%, 15%. 5-4, not always the same 5-4. There were 18 5-4 cases. 12 of them were different combinations. Okay. So, and I'm sure in each of those 12, they said in the press, in an unusual combinations. I said 12 out of 18 is horrible. Anyway, you get that. Okay. So it's not the same group all the time, and they're difficult cases, and people can have legal views. And after all, on that court, you do see how what you learned in the 7th grade or 12th grade or whatever about the United States of America is relevant. It's relevant. Because it's not in its how, that takes me 4 hours, forget it. But it's there. And that's called political science. I grew up in San Francisco, just after World War II. I went to Lowell High School. I went to Stanford and law school at Harvard. And does that affect me? Of course it does. You can't jump out of your own skin. You try to have not affect you. Yes, you do. You try to get this right on the law. You have difficult legal questions, two sides to it, and you think you can escape your own skin? No. What about insulting your colleagues? Don't do it. But I got a question from a Georgetown student group. They said, Nino and I like to debate together. And they said, what do you think about writing, in your opinion, something terrible about your colleague? And I said, I'm not going to let Nino answer that question. I know it's directed to him. But I'll tell you what I think. I think that some people have a disease. It's called good writer's disease. And they find a felicitous phrase. And when you ask them to give up that felicitous phrase, they cannot do it any more than a good comedian can give up a good joke. I mean, you've seen good comedians, you know, it's their job. Yeah, it's funny, but that's why they did it. And I said, we know that. He does it. He's able to write those phrases. I can't, but he can. Okay, I'm not going to convince him. I've tried sometime, but we take that into account. Okay, so that's it. We take it into account. Don't do it. Yeah. Okay, I understand. The person who said, and sometimes it is political. What is an example of an absolute political case? I used the first miscegenation case. Frankfurter said to the conference, if we take this case, we've got to hold that Virginia's law against miscegenation is unconstitutional and will never get Brown enforced. When I was a law clerk, 64, 10 years after Brown, looking back on it, I worked for Arthur Goldberg. That court was a court that had one mission in mind. How do we get Brown enforced? You say? Yeah. And by the way, a few years later, they did take a miscegenation case, Loving, and they did say it was unconstitutional, but by then it was okay. They were not going to interfere with Brown. Is that political? Yeah. Yeah, there's some of that. But the best single sentence about politics in the court was Paul Freund's. He said, no judge, he's a great constitutional law professor, and he said, no judge decides a case according to the temperature of the day. You have a criminal case. You want that judge to be looking over his shoulder at what the opinion? No judge decides a case according to the temperature of the day. But every judge is aware of the climate of the season. And if that were not true, how did we go from Lochner to the New Deal? And if you want to see all the steps in between that, and how did we go from let's let the legislature do whatever it wants to Brown in the civil rights cases? So you say, can I say more about that? No, I doubt that you want me to say more about that. And luckily for you, I can't say more about that because I don't know much more about that. But when I read Paul Freund, yeah. And where does this all put us right this minute? Can I say where?
Yes.
Okay. I think we have a problem. And we have two audiences. And the problem, it's not necessarily politics. They don't always decide for Mr. Trump. I mean, it isn't really true that it's different views of the law. But the problem isn't even with judges and lawyers. I think this is my own personal view. It is a problem of division. It is a problem of division within the country. It is a problem of division of political thought. It is a problem of division of how you want to live, of what's appropriate way to live your life. There is a problem. And so the way I phrase this question is, what is it that judges and lawyers can do with this more basic problem? What? And as you can tell, I don't think judges can do much. They can do their job and maybe a little more, like your group who explain and so forth. But I have some ideas about that, but I'm not going to say what they are unless you ask me.
And so if the justice were to say, if you asked me, I would explain more, then I would say, please.
Well, it's a little complicated.
I know.
But I think
Well, you haven't written a book on this precise subject. So
No, I haven't put it down.
This is a preview.
It's my next book.
Next book.
Okay, look, it's the lawyers. That's what I told the woman who's president of Ghana. I said, the people you have to convince that a rule of law is desirable. The people are in the villages. The people are in the towns. Contrary to popular belief, of the 340 million in the United States, 339 million are not lawyers. Okay. But lawyers are better having them explain it to having lawyers than judges. And who do you have to explain it to? Two audiences. The first audience, I think, is in the more distant future, but do it now. The first audience are the 7th graders, the 12th graders, the law school students even. And what is it I tell them when I talk to the 7th graders? And I do if I possibly have the chance. When I talk to the 7th graders, hey, you try that. They're all looking out the window. Okay, so I do this little gimmick, take out the Constitution. And they say, what should we do? Somebody says, what about that? That's the Constitution, but I say, I don't, my friend, it is your Constitution now. And Joanna said to each of our grandchildren, $20 if you memorize the Gettysburg Address. Why? Think of those first two. I tell them that. The first 2 lines. 7 years ago, our fathers set forth upon this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. And we are now engaged in a great war to see whether this nation or any nation so conceived and so dedicated can long endure. And I found letters by George Washington when he said the same. He called it the Great Experiment. There's those professors over in France, the Lumiere, they're like our college professors at Harvard. They think they have great ideas, but nobody can actually do it except them. Yes. Okay, no, we're going to do it. We're going to have a country that reason, at least in part, can move, and it will protect liberty, democracy, rule of law, equality. Yes, we're going to really do it. And that's what Lincoln's talking about. And that's what Washington's talking about. And then I say to the 7th graders, my friends, it's yours. And now this experiment is up to you. And the only thing that makes me optimistic is not what I just said, but rather they're not looking out the window. They've come back to their seats. And maybe I make it up on something I do, but there is a look in their eyes. And that look in their eyes, yeah, yes, we can. Yes, we can do it. You said, and that's the audience. That's the audience for the lawyers on law day. That's the audience, even if the editorial board, which you tried first, was a little hostile. Talk to them anyway, and talk to the law schools. Talk to the undergraduates. Talk. But you will feel in your bones what this rule of law is, and so you explain the best you can what you think it is. And why it's that audience that you're talking to that has to see whether this experiment works. And you will find, because that's what I learned in the 5th grade from Miss Quataquatsa at Grant School in San Francisco, that what we're going to do, she put 4 students in each group, and they had to write an essay of San Francisco, a metropolitan city, or or the city that whatever it was, and they got 1 grade. Hey, 1 grade. Might pay attention to what the others think. Yeah. And COVID, there were groups in Cambridge, Mass, went around to see whether the old people are doing all right. And I bet they were in Chicago. And I bet they were in St. Louis and San Diego, because we're not so bad. Not so bad at that, despite division now and all the difficult problems. And all that's what makes me optimistic. And that's the most I can suggest. Job is the lawyers, it's talking to other people, it's explaining the system, it's be sure they learn that they have to participate or this Constitution won't work. It's listening to other people. That's enough for now.
Okay. Well, I think Steve is a little modest when he said he can't turn a phrase, because what he just said, I think, is really encapsulated in one of his opinions from long ago, which was, and you'll correct me if I'm wrong, I'm sure. But that's the role of the Supreme Court over the lower federal courts, yes. But he said, public education is the nursery of democracy. And I thought that was really a beautiful way to put in. So this morning, we've been talking about the public participation in the conversation. We've been talking about judicial threats, judicial independence. So I'm interested to hear your view on kind of the environment now for judges, particularly judicial threats. And does it matter who's doing the threatening and who's doing the talking?
Sure. Well, I mean, it's terribly unfortunate that the level of threats has been increasing. You can look at data from the Marshal Service. You can look at what's happening in state courts as well. We have state court colleagues here with us. Hello, it's good to see you again, Deborah. And so I see it two ways. Number one, with colleagues who've experienced the very worst of this, I have never seen a judge who I think put a thumb in the scale at all about the way he or she was going to perform the job as judge in light of this background atmosphere of actual or potential threats, whether it's whether, you know, I remember at one point I had somebody stalking me. One point, my favorite threat was a guy who sent me a letter saying, you know, I know where you live and I've got my people following you. But then he drew a picture of himself and he called himself the almighty 400 because he said he could bench press 400 pounds. You know, well, I gave the letter to the marshals, but it was not cause for too much harm. But there are real things that are designed to undermine one's sense of well-being, like the pizza deliveries. I mean, getting a pizza at your door isn't like having somebody put a gun in your face, but on the other hand, it's like we could if we wanted to,
because we know where you live.
Because we know where you live, we know where your children are, and where your grandchildren go to school, or you know whatever. That's just awful. And what I worry about is that it may, in the long run, have an effect on who's willing to be a judge. It's an incredible privilege to be in a position, whether it's the district court or the Court of Appeals or any other court's amazing. But people that I know don't want to put their families at risk. You know, they feel like, well, I'll take the consequences of decisions for myself, but not my family. So I feel like the threats themselves have been sort of enabled by what we see all the time in the news, whether it's the January 6th rioting of the Capitol. There's some normalization of violence, which worries me terribly. You know, I feel deadened to, oh, here's another story about, 10 more people were killed with guns, or some guy comes rushing through the National Press dinner and, armed to the teeth. It's just awful. And it's really, it's not just judges. It's bad for our ability to self-govern at large. And we can take preventive measures for judges. You can have a security system in your house. Marshals do a wonderful job at the courthouse and wherever they can. But there's only so much that's going to do. It's again, I feel like lowering the temperature of debate, maybe addressing this problem of division that Steve is talking about is essential. Because if anybody ever wondered whether law itself is going to do the job helping our country survive into the next couple of centuries, the answer is no. You need much more than law. You need civil society. You need people respecting one another. When I go out to Indiana, having a nice exchange with my neighbors who probably all voted for a different person for president than I did, but they're really nice people. I enjoy being with them. And we don't talk about politics very much, but that's good, actually. It means that we rediscover the human connections that we have, and there's so many of them. I happen to love Venn diagrams, and I really think the overlap is big when you start talking to people in a non-political way. People love their families. They want to provide for them. They enjoy whatever their hobbies happen to be. There's just so much that unites us. And we have somehow lost track, I think, of how to do that. But I think without that kind of civil society underlying whatever we put the laws on top of, the laws are just for the extreme situations where you actually, you have somebody robs a bank, of course, you've got to do something about that and similar things. So I do think that the threats of violence are, of course, they're awful against judges. It's happened to state legislators as well. It's happened to, it happened in Congress, right? Steve Scalise. So we've just got to, as a society, start changing the narrative so that better ways of getting along with one another are given more prominence. I don't care if it's a garden club. I mean, I don't know what people do, but something. My own personal hobby is playing the oboe. So, if you want to hear the oboe, which I practice right here in this very room. But just something that reignites the notion that we are all humans, that we are all in this together, and that we are not going to let this wild rhetoric get carried away.
Well, but I couldn't agree more with that. And I would, of course, there's been a big increase in the security people at the Supreme Court. My God. And you can think, what's the theoretical? Look, when was the last time you actually got some billfold, cash, and paid for the gasoline? Some of the time. But much of the time, I put a card in a machine. And that means the connection between the person who worked at the service station and me is less than it was. And that's happened all over the place. Mm-hmm. But how do we get that? Well, I don't know. I don't know the answer to that. Maybe that's gone forever. Maybe all these technical blah, blah, blah. But nonetheless, as lawyers, we have a chance to do something that the society is now calling for us to do, and we have some expertise. So one thing we can do, we can talk. We're pretty good at that. And we know some of this law. And we know that Abraham Lincoln was pointing to, 7 years ago. And what was he bringing forth? 7 was the Declaration of Independence. And what are they? It is, what's the word? It's Jefferson. It made him immortal. What's the first part of that?
When in the court.
No, this next sentence. What? Life, liberty. Yeah, but before life, liberty, they're given to us the life, liberty. What? That's the last sentence. What's the first sentence? What?
Get that book.
There's just, What's in my, there we go. That's what happens as you get older. But nonetheless, it's a great sentence, and it's about America. And it does say, it made him immortal. It's given to us. It's a, what?
Inalienable.
What? Yeah, but that's before that. I gotta look it up. Don't tell anyone I couldn't even.
That's why you always carry a copy.
We hold these truths to be self-evident. That's it. Right. All men are created equal. They are endowed by their creator with certain inalienable rights, and among these are life, liberty, and the pursuit of happiness. But to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. That's democracy. And so if you don't like, there are certain opinions of the Supreme Court, which I have not liked. Okay. So if they say something like, worry that everybody's going to go around. I'll say what worries me a lot of aspects. They're going to go have gerrymandering everywhere. First one state and the other state. What happens to democracy? But there's one important thing about a case like that in the Supreme Court, and even results you don't like. Hey, you don't have to do it. Nobody says they have to gerrymander. Nobody says they have to make one blue state, one red state, one red state, one green state. I don't know what they're going to do, but nobody says they have to. And do lawyers have some view about democracy? Many of them do. Okay. You don't have to take that as an example. Take any example you want. But you go talk to people who aren't lawyers, the 339 million of them. You talk to some of them, a few of them, the school's children. I've said this already. The editorial boards, the PTA, it used to be, that's where my mother would go every in the second grade at Grant and sure, dozens of things that you're all involved in. And you know something that most of the people in that room don't know. And that is why every group under the sun, my mother used to say this. She'd say, you know, every race, every religion, every point of view, and she'd add to that because she's from San Francisco. Or she'd add, and there's no view so crazy there isn't somebody in this country who doesn't hold it. And then she was, don't tell anyone I said. She said, and they live in Los Angeles. She'd say. But that's where we are. And so the question is, that's where we are, and what can we do? And I'm not going to change the screens on United Airlines, and I'm not going to change the fact that I fight like mad so my grandchildren aren't looking at the screen 42 hours every day. And we can have some effect there, but not too much. But here we can. Here we can. The judges a little, lawyers, I think, comparatively speaking, a lot. So that's my point.
That would be a great place to end, but it wouldn't permit me to then ask what I think a lot of people in this room are interested in, and that is the emergency or the shadow docket. So can you tell us in brief words what it is? You know, it's not a totally new phenomenon. The labeling of it as the shadow docket is newer, of course. But yeah. But are the cases changing? What's happening? Because
that's what I mean, people have different views of it. Every court, your court, every court has an emergency docket. Because say a district judge issues an injunction or doesn't, and the other side thinks they're wrong. So they go to the next higher court and say they're wrong. And you have to look at it, what's going to be the status quo while they decide the case. That's all. And sometimes they say yes, and sometimes they say no. Okay, that's it. Now, here is the immediate problem. In my opinion, remember there are other opinions. In my opinion, the nature of the cases has changed. See, when I was there 28 years, almost all of them were death cases. And the death cases, almost all of them, had been to the court 3 times already. All right, so it wasn't too tough. And if you think there's nothing to the case, you just say there's nothing. And the circuits are divided among the judges. But sometimes there is. And sometimes it was an election case and there was more to it. If there's something to it, what I would do and what the others do is they refer it to the whole court. Mm-hmm. Now, when they refer it to the whole court, you have to write a memo and then there's some briefs and you go through monkey business and then the court votes. And then Roberts, as chief, will write the result, probably if he's on that side. Okay, so he writes it. And what many say, you can't find the opposing view, though I know it. He writes one sentence or he writes one paragraph. Hey, the point of the court is to explain. Their only power is explaining. So why don't they write more?
That's a good question. Why?
Yeah, here, why? Why do I think they don't write more? Remember, there are other views. I think they don't write more because if I were Robert sitting there and you see the kind of the case now that makes it come up more often. First, there was COVID. There were a bunch of those because there was vaccination and religious things and so forth. The second is if you want to change the structure of the federal government in major ways, the court feels, hey, we better see what's going on here as quick as possible. And we've had more cases on that. All right. Where that's a fair characterization. Changes, okay? In the structure. Those are big deal cases. If a big deal case, you know, now, we decide, you have the votes. What shall Roberts want? Here's what I believe he will think. He hasn't said this, so it's only me. Okay. Hey, if I write, maybe somebody else will write. Do I want somebody else to write? Do I want 4 opinions in this emergency matter? But why not? Many reasons, but the main one would be once a person writes something, he tends to be wedded. He has a hard time getting out of it. And we've not yet heard the oral argument, and we've not yet read the full briefing. So I better keep this down, what I say, to try to minimize the opinions. Now, that's a point. Mm-hmm. And I'm not saying that point should always win, and I'm not saying it should always lose. But I think there are 2 sides to this about how much you write And it depends on the case, and it depends on the situation in the court, and you certainly can't say anything about it publicly. And there we are. So that's my view of the emergency doc.
Well, I'm going to give a special privilege to Bob Cummins here, one of our creators and sponsors, to ask one question, and then I'm going to give you all the last word. So Bob, you have a question?
I think we're here today because
You want to give them the mic?
You want
we
the mic?
did. I think we're here today because of survival. There's a powerful segment in this country that doesn't hold these truths to be self-evident. And so how do we deal with that?
Diane?
Well, there's an easy.
I have a softball question for you, Diane.
Right. Well, the first thing I would say is that the role of the judge is, assuming there's litigation that brings this case before a court. Obviously, courts don't self-initiate litigation, but if there is a case that comes before the court, judges have to look out for the rights of the minority. They have to look out for the rights of the less popular. And that's goes all the way back to that judicial independence point that we were talking about. So if it's somebody who doesn't hold these truths to be self-evident, and those truths happen to be embodied in parts of our Constitution, our Bill of Rights, the original Constitution, or legislation, it's up to the courts to enforce the rights as they are. And even if people don't like them, it's difficult when you have something like the January 6th riots, and then the president decides to pardon all of them, basically, all of those people. What does that say about rule of law? A big topic I don't think I can get into, but it's, I think we have to understand that opponents of our entire system of government have the right to talk about that if they want to. But when it comes down to individuals, the judicial system has to be supportive of them.
Well, I'm going to regrettably have to wrap this up. We have two jurists who have left the bench and found very productive lives afterward, both in, of course, academia and the American Law Institute, at Harvard, at Chicago. But I want to give you one last word, because we have a lot of people online, and we have people here and in the overflow room, to say, where do we go from here? Because we've had a lot of talk about the importance, about the critical nature of our foundational documents. Where do we go from here? So I'll start with you, Justice Breyer.
No, I think Cummings had good questions, and I'd start there. And I would just say this, that what I'd say to that person, I'd say, what are those rights they're talking about? Go read the Declaration, go read Lincoln, go read, and what are they? Basically, democracy, basic human liberties, equality, rule of law. Are you telling me you don't really believe in that? They won't say that. But if they did, I'd say you're entitled to your opinion. But I'll tell you something. This country, there are two kinds of countries, and neither of these is good or bad. But there are countries, which I've read, where the basic principle is heredity. And it might be that you're a member of a certain tribe. It might be you're a member of a certain group. It might be a member of a certain class. There are also countries, and we're one of them, where the basic idea is documents. They get people together from a lot of these different groups who agree to live under certain documents. And we have agreed for 250 years to live under documents like the Declaration of Independence, the Constitution, Lincoln's speech, and others. Now, has that worked? I'd say you judge, Mr. Non-Liberty. You judge. We've had some terrible times. This is a country that's had slavery. This is a country that's had a civil war. This is a country that's had Jim Crow. This is a country that's had you name it. But now we are no longer 4 million. We are 340 million. And despite our downs, which are quite a few, we've ended up perhaps on balance with ups. And so the only argument I could make to you when you say do not follow these documents is to say that's what we've done. And we're still a country that has cooperation, that tries to teach its school children, that tries to see that people have some kind of a chance, at least in ideal. And we've tried, not always successfully. And you want us to stop trying? Please, you don't. That's what I would say.
Diane?
All I will add to that, but there's really nothing to add, is that one criticism I sometimes hear is about the failures of American society, whether it's the failures with respect to the period when slavery existed, whether it's Indian removal and the whole sweep of problems vis-a-vis the indigenous people on these continents. But I think it's a good thing to have goals to aspire to, and what we have in the Constitution and the Declaration are aspirational as much as they are statements that, you know, if we haven't achieved this on day one, then we have to pack up our suitcase and go home. It's good to aspire, and it helps give a positive and hopeful tone to the things that we're doing, and helps inspire those seventh graders and maybe even the second graders to feel good about their country and their fellow citizens.
And what you want a sentence quote on that? The person, I can't remember his name, they used to have black universities, and still do in places in the South. The president of one of them is well known. I can't think of his name naturally. He taught Martin Luther King. Yeah. No, he taught Martin Luther King. And his favorite saying, which he gave often he says, "It is not a sin not to achieve your goals. It is not a sin not to reach the stars. It is a sin to have no goals to reach. It is a sin to have no stars to try to get to."
And with that,